Yes. Let it be on Monday.
The court proceedings of the case pertaining to Kohima bench is conducted through a remote video conferencing. Post of Mr. N. Longkumar,
Yes, my lord.
learned counsel for a review petitioner, has submitted that the matter be listed on 2/12/2024. Post of Mr. M.T. Chung and State Counsel for appearing for all the respondents has submitted that he has no objection to the said prayer. Post of in view of the prayer so made and as agreed to by the Land State Council, please the matter be listed on 2/12/2024.
Principal seat matter, attention one for motion.
My principal. This is an application for 82 of the businesses for seeking PRS bail. Your lordship, FIR is page 12. It is the second application.
Okay.
Earlier approached this court. and
B.
Lordship.
FIR?
FIR page 12. Your lordship. Petitioner is not naming the FIR. This FIR is lodged by one executive engineer against the earlier executive engineer, your lordship. Junior engineer.
I have no
Page
honor
12.
to inform that Rohima Khatul and Lalbhanu Nessa complaint to immediate pump sets have been taken from her supporting your signature. As a signature, do not tell you the signature of stock. Yes.
Lordship. The petitioners, they are not named. They are the employee contractor for installing the pump set. They are not the authority, your lordship. Now, your lordship, page 16, the order in favor of the petitioners.
Who are the petitioners?
Petitioners here is Hamidur Rahman Khandapar and one Nasir Hussain, your lordship. They are the employee contractor.
Hamidur Rahman.
Hamidur,
Yes.
lordship. Your lordship. Page 16, work order, your lordship. Serial number 8.
When the FIR was filed? 2012. Okay. Yes.
Now, lordship, they have installed the pump set and this is the inquiry report. Inquiry report, I have annexed.
Okay.
It is start from your lordship, page 20.
This 16 is a work order.
Work order, your lordship. Their petitioners are interested. It is Hamidur Rahman Akon. Serial number 8, your lordship. Lalbhanu Nessa, the beneficiary, your lordship.
Yes.
Beneficiary, your lordship. After that inquiry report, your lordship, page 22 in favor of the petitioner 1.
20.
20 start from 22, your lordship. Executive just submitted before the chief engineer start from 22 and relevant portion inspection report, your lordship. Relevant portion, page 27. That she has received by putting signature. Page Lalbhanu Nessa, collect water CPM, satisfactory. He has received the pumps. As per direction of the official, we have installed the pumps here. Only duty, my duty is only install the pumps here. And next page, your lordship, page 28. In the joint verification report.
No, this is about Hamidur Rahman.
Hamidur Rahman, yes.
Ah.
And another, your lordship, page 30.
No, who is the other one?
Nasir
Nasir
Hussain.
Hussain.
Nasir Hussain. Page 30 in the work order. And in
Page
page 30, your lordship.
30 work order.
Work order, your lordship. And the report, your lordship, page 33. Inquiry report.
30
33.
work order.
Work order 30, your lordship.
That
And-
is inspection report.
Inspection report is work order, your lordship, year for 1921, page 19, your lordship. Page 19 in the work order. And name of the beneficiary, serial number, your lordship, serial number 322, Rohima Khatun.
Serial number?
322, Rohima Khatun. That's got it. Page 19. Yes. Work order dated 21 to 19 in favor of the petitioner 2. And
Yes, which one is the?
inspection report page 30, start from page 30 in favor of Nasir Hussain. And your lordship page 33 in inspection report. That's
Hmm.
serial number 17, Rohima Khatun, so and so, collected good, satisfactory. Sir. And thereafter joint verification report also, page 34, all the officials.
No, why it has come? Why this AB is listed here?
No, earlier your lordship closed this petition not to entertain us because there is no, there is also mistake on part also, our part also, page 42 is the order here. Second application is there. Relevant portion, your lordship, page para 5, your lordship. There is some mistake on my part also. There are 5 and 8.
This is your statement I have
Yes,
recorded.
There is some mistake on
Huh?
my part also because inadvertently I have not annexed that work order, your lordship. Some other work order is annexed. It was I have stated and
That
paragraph
was on 7/8/2020.
20. your lordship.
Now you are producing documents of 2019 now.
No, your lordship, that document.
Huh?
Lordship.
Is it not?
Lordship. On that time, your is that document or not?
Work order was of 2000, January 2019.
Lordship, that work order, your lordship.
Then this installation report when?
20, your lordship.
Prior to that disposal?
Prior to disposal, your lordship.
Prior to.
I have stated in my paragraph at while your lordship. Paragraph 6, your lordship, there is mistake on 5 also and inter. Event portion, your lordship, page para 8 also, your lordship and your lordship order page 44. Your lordship. That it is not attended, there is no apprehension that is closed, your lordship. But suddenly the police has visited the house of the petitioner and inquired about them at night hour and physically assaulted one nephew of the petitioner number 2. I have stated paragraph 9.
Paragraph 6 I have recorded. What should be contained in an anticipated bail application?
Lordship. And now your lordship, that's why your lordship has closed this petition. Paragraph 8 also, learned APP has submitted. Notice also not served. And ever means the petition found in lordship. That's why consider view that Canton United or lack of essential facts, grant of benefit period is bail, the petition under section 436 in conclusion.
Yes, Mr.
Now your lordship.
PP.
My lord, this earlier, my lord, the same ground, my lord, on 7/8/2022.
That day, Mr. Islam submitted that
Yes, my lord.
paragraph 5 I have recorded.
Yes, my lord.
Then
Even-
constitution when judgment that he has
Yes,
to
yes,
lay the basic foundation.
Yes, my lord. Even my lord was pleased to, my lord, record it in the para 7 of the, my lord,
Yes.
the order, my lord. The same way, my lord, that is present, but whatever maybe, my lord, let the city maybe call for, my lord. On the next day.
Because these are subsequent documents on joint inspection report,
My
whatever,
lord, my lord.
after disposal, because we gave them benefit of doubt because application was not entertained.
My lord,
It was not dismissed
my lord, not entered in what is used by.
because of lack of essential and
My-
bare minimum facts.
My lord.
Okay. Right, Mr. S. You get the documents, paper, case diary?
Well.
Yes, Islam. Learned counsel for the petitioners. And Mr.
K. Bush, my lord.
K. Bush, learned additional public prosecutor for the respondent state. Post of 438, 2 petitioners pending arrest in connection with Gauripur police station case numbers, for instance.
216.
The petitioners had earlier approached this court by OF and another application, AB 1677 to 2020, seeking the benefit of pre-arrest bail under section 438 CRPC. Now anticipated bail is under 482.
My lord, 482.
Okay. Full stop. The said application, AB so and so, was not entertained. Because of lack of essential facts in the said application to extend the benefit of pre-arrest bail to the petitioners. Full stop, para. আগৰ অৰ্ডাৰটো paragraph 3 টো লিখি দিব, page 43 আছে। আৰু paragraph 4 টো লিখি দিব। Paragraph 4 first line টো লিখি দিব খালি, first line টো। Paragraph 5 or the two petitioners have claimed that they are empaneled contractors under the Agriculture Department, Government of Assam for installation stroke boring of pump sets to the beneficiaries. Full stop. Para. In this application, preferred under 482 Bharatiya Nagarik Suraksha সংঘালী এইটো
Yes.
প্ৰথমত ফাৰ্ষ্ট পেৰাটো have projected that the petition number 1 was issued and work order dated 14/1/2019 Annexure 2 for installation of diesel pump sets to 35 number of beneficiaries, which included Lal Bhanu Nessa as a beneficiary. Full stop. Petition number 2 has stated that he was issued and work order dated
Yes, 19. 21/1/2019. Page 19.
21/1/2019 Annexure 3 for so-and-so installation of so-and-so for 78 number of beneficiaries, which included
Rohima.
the name of Rohima Khatun as one of the beneficiaries. Full stop. The petitioners, by referring to the joint verification report for installation of diesel pump sets, annexed as Annexure 4 and Annexure 5 to this application, more particularly, Annexure 4 installation reports dated 30/10/12/2020 and dated 15/2/2021, annexed as Annexure 4 and Annexure 5 respectively, more particularly, at our Annexure 5 at page
Page 33. 33 and 34. Page
33.
and 34.
33. 33 নহয় ৰ'ব।
No, your lordship. Page 27 And 29.
27, within bracket annexer 4 bracket rako and page 27
Seven.
আৰু annexer 5 bracket page
30.
33. I've submitted that the diesel pump sets had been installed and as per the said joint verification reports, the installation was found to be satisfactory. Post of para. With the case, consent case diary of so and so be called for. Post of Mr. Learned Additional Public Prosecutor shall produce the case diary on
My lord, 10th December.
para having regard to the projections made by the petitioner in this petition in the apostate manner, it is provided in the interim that 25,000 each, 1 COT to the satisfaction of the IO appear before the 10 days from today. Again, like it. Oh,
16.
16.
16. Obvious.
Item number 2.
May I please wait? My lord, in this case, lordship, the petitioner lordship has challenged lordship,
Who is the petitioner?
petitioner lordship is the employee of LDA lordship working in the district court lordship Morigaon.
District?
District and session judge, under district and session judge Morigaon lordship.
LDA.
LDA.
Yes.
Lordship, respondent number 4, lordship, district and session judge, lordship has prepared a draft gradation list, lordship. Wherein lordship, my serial
Draft gradation list.
For selecting lordship,
What is your name?
A Hussain lordship.
Arunul Rasid. Yes, your name appears where?
Serial number lordship 24 lordship.
Page?
Page 36 lordship. Lordship, before me lordship, some copyist, computer typist and typist lordship, their name has been lordship reflected lordship. In the established in the role lordship, rule 6.4 lordship, where it is clearly mentioned that
Rule
6.4 of district and session judge establishment ministerial service rule lordship 1987.
page
Page 23 can be seen. Upper division assistant by promotion on the basis of seniority come merit from among
page 20,
3 lords. I have,
page 23.
yes, ma'am.
Yes.
Regarding lordship promotion to the upper division assistant, UDL lordship. By promotion on the basis of seniority come merit from among the lower division assistant of the district and session judge establishment who have rendered not less than 5 years of service on the first day of the year in which the promotion is made, lordship. Lordship, here, lordship, in the establishment there is no any cadre, lordship, computer typist, lordship. On the other hand, lordship, typist and copyist, lordship. Their promotion, lordship, mentioned in establishment, lordship, rule 6.5 B and C, lordship. B and C, lordship. As per notification, lordship, of the High Court, lordship, their post, lordship,
Which
copies,
notification?
notification, lordship, can you see, lordship, page 30,
Page?
30.
Huh.
In this notification, lordship, the Honorable High Court has been pleased to notify that henceforth the post of computer typist in the subordinate courts of Assam shall be treated as equivalent to LDA copyist and typist for the purpose of promotion, since their pay scale is the same as that of LDA copyist and typist. But in establishment, Lordship, I'm saying, Lordship, rule. Lordship, there is no any cadre. Lordship, computer typist. In similar situated case, Lordship, I have annexed, Lordship, can you see your Lordship orders? Page 49. 44, Lordship. Relevant portion is page 46, Lordship. Last para. 47, last para. Prime FSC, it appears that the post of computer typist, Lordship, page 47. Your Lordship order. Similar case, Lordship. It appears that the post of computer typist in the establishment of assembly number 3 is not part of the rules.
Para?
Para number 7. Last para.
Hmm.
Prime FSC, it appears that the post of computer typist in the establishment of the respondent number 3 is not part of the rules, 1987. As the post of computer typist, that is the prime FSC and X cadre post, and no amendment has been made in the rule 1987 to bring them as members of the state service. Therefore,
Now, what is your apprehension now?
my lord,
Hmm?
my fair lordship, in the meantime, lordship, the draft gazetteon lordship kindly be straight and promotion cannot be made, lordship. Among those cadres, there
Yes, madam.
Notices may go, on the interim prayer, my lord, it may be heard on the next day.
What? Come to the rules.
yes, ma'am.
Show us. First, you see page 20.
Yes, ma'am.
Page 20.
Yes,
It
ma'am.
is the governor of Assam. Governor of Assam. It is not under Article 229. It is under the proviso to Article 309. Then
On the other hand, lordship, till today, lordship, there is no any amendment in the establishment, lordship.
where is that notification?
Notification, ma'am.
That equivalent?
32, ma'am. Page 32.
33. 33 or 34?
32, ma'am.
32. Is to treated as equivalent. This is not by government. And this is not 229 also, 309.
No reference.
Hart, Mr.
A. Hussein.
A. Hussein,
Yes, sir.
learned counsel for the petition. Any state counsel? Ms. S. Sharma, learned standing counsel. Guwahati High Court for the respondent number 2 and 3. Full stop. The petitioner has stated that he is presently serving as a lower division assistant. Of 2, 3, and 4. 2, 3, and 4. In the establishment of the respondent number 4. Full stop. Para. By full stop. And his conditions of service is regulated. Sorry, no. And he is a member of the Assam District and Sessions Judges Establishment within bracket Ministerial Service. Full stop. It is stated that as such member, his conditions of service are regulated by the Assam District and Sessions Judges Establishment within bracket Ministerial Service Rules, 1987 within bracket the 1987 rules or the rules 1987 for short. Full stop. The petitioner has approached this court by this writ petition agreed by a notification dated 4/3/2020 Annexure 4 and a notification dated 14/10/2020 Annexure 6, both issued under the hand of the respondent number 3, whereby the post of copyist, typist and computer typist working in the district judiciary, who possess the minimum educational qualification under the existing rules, have been treated as equivalent for the purpose of promotion to the post of UDA, which is are equivalent for the purpose of promotion to the UDA, with all LDS working in the district judiciary. Full stop. It is the contention of the petitioner that the copyist, typist, computer typist are not members of the Assam District and Session Judges Establishment within bracket Ministerial Service Rules. Full stop. But the respondent authorities acting on those notifications, have prepared a gradation list for the year 2024. Annexure
7.
7. For the purpose of promoting inter alia, for the purpose of carrying out inter alia an exercise of promotion to the post of UDA. Full stop. The petitioner has projected that when the actually page 53, the petitioner, paragraph 4 to leave, paragraph 4. Paragraph 4 to leave. Issue notice returnable in 4 weeks. Next, as MS Somal as Standing Council Guwahati High Court has appeared and accepted notice on behalf of the respondent number 2, 3, and 4. No formal notices are needed to be issued to the said respondents. The counsel for the petitioner shall have furnish requisite number of extra copies of the writ petition along with annexes to the learned to MS Sharma within 3 working days from today. Full stop. The learned counsel for the petitioner shall furnish an extra copy of the writ petition along with annexer to the senior government advocate Assam for the purpose of service upon the respondent number 1 within 3 working days from today. Full stop. Clara. The learned counsel for the petitioner has submitted that if he has a genuine apprehension that the respondent authority is acting on the gradation list within bracket exhibit, annexer 7, is likely to undertake an exercise for promoting incumbents holding the post of copyist, typist, computer typist. In the meantime, if such an exercise is undertaken, the petitioner, who is a member of the service, is likely to be prejudicially affected, as any such promotion from the post of copyist, typist, computer typist would amount to a promotion from an ex-cadre post. Full stop. But having considered the submissions of the learned counsel for the parties and the provisions of the rules 1987, more particularly, rule 6 within bracket 4 thereof, it is provided in the interim that till the returnable date, there shall not be any promotion from to the post of UD in the establishment of the respondent number 4 from the post of typist stroke copyist, typist stroke computer typist.
Thank you, Lord. Milord, before I open my brief, I should candidly mention that here is a case which is a hard one. Losses may have to, for this particular case, keep aside the rigors of the technicalities of law to do justice to this person who happens to be a member of the downtrodden class. Now, what happened, my lord? A post of grade 4 peon was advertised in the office of the special judge CBI here. Selection took place. I was one of the candidates belonging to OBC category. Finally, select list was published. It has 2 parts. First part, one merit list, then the waiting list. There was one person in the merit list, upper part of the list. In the lower part, 2 persons. One was another, I was the second. In the wait list, they call it, if we can treat it. Now, the first one on merit, he failed to satisfy the authorities at the time of verification of records. So he could not be appointed. So then other part of the list came into 4. And then the first one in the list was appointed. Unfortunately, that person expired. After 2-3 months, he expired. Within the validity period of the list, 1 year. And then my name only remained in the list. So I made a prayer that kindly consider my case and I should be appointed. Authority remained silent. I had to approach this honorable court. Lordship should notice. Now, as I see, he was a person, this petitioner, who was selected, and the post is the grade 4 in the lowest rank of the service. Post fell vacant. No doubt, initially one was appointed. But unfortunately, that post again arose, fell vacant within the validity period of the list itself. Therefore, whether I can be appointed against that vacancy. This is the simple question. Now, let me also be candid that interpretation of law goes to the extent that once the post is filled up, there is no vacancy further. And if the vacancy arises, that is a fresh vacancy, new vacancy, may have to be filled up by following the due process of law again. But now, that is why I urge upon your lordships that a person belonging to the downtrodden section of the society and having been selected on merit by one exercise taken by the authorities, and when the post fell vacant within 1 year itself, equity demands that he needs a consideration. To that extent, my humble prayer is, my lord, it will not affect anybody's right. It will not anyway cause injustice to anybody, but it will cause justice to me. A family will be benefited.
Now, okay. Mr. Mohanto,
My lord.
law
Yes.
and justice.
Yes. They are conflicting because
Now,
this is the court of
whether
equity.
law and justice can go separate ways, or justice has to be done within the 4 corners of the law.
My lord, right? Lordship is right.
Because
I am, if I,
otherwise my perception is
Yeah.
that justice to be done within the 4 corners of the law.
my lord, this is normal. Yes, I agree to your lordship.
Cannot
let-
go separate ways.
But then there is slightly a dividing line.
Where is the discretion
There,
for the court to
Yes.
go beyond settled position of law?
no, my lord, I will say like this. My submission will be like, that is why I opened my mouth saying that maybe the rigors of the law may have prevented from doing justice. This is technicalities of law. But since this honorable court is the court of equity, so equitable principles only will guide it. And the principle of equity is this: where law fails to deliver the justice, equity comes to play. That is the principle, my lord. And that's how this honorable court retains the power under 226 to pass specific orders in certain cases where this honorable court may feel that no injustice will be done to anybody, no prejudice will be caused to anybody, but justice needs to be done in a particular case. It will not form any precedence in future. It may not be treated as a precedence in future, but this case needs a little sympathy, little consideration, and equitable principles will be applied to do justice to the petitioner. Therefore, only that little arena, Lordship will appreciate kindly that law and equity, they go side by side. Nobody will come in to dislodge the other. But the power under 226 is such that this is a court having both the powers, law and equity.
Now, one question.
But
Once it was advertisement was for how many posts?
one post.
One post.
One. Only one post. Lordship will kindly see.
And somebody joined.
Yes,
Somebody got appointed.
yes,
If he had joined after being appointed,
yes.
what is the question of validity of the waiting, select list or waiting list?
My lord, as I said, my lord, otherwise the post is filled up, process is complete, gone. Gone, that way. That way, the
Post is one.
post is one. Post is one. Had there been two posts, probably there would not have been any difficulty. But one post. And, my lord, in such situation, I'm there. But
Yes,
the-
case would have been different. Suppose there are 5 posts.
Yes,
Select list is prepared for 5, waiting list is also 5. And something happened. And 5 were not appointed. Yes, there is a waiting list. The consideration would have been quite different.
yes, then consideration differs. Then consideration differs. But here, but that is why I'm saying, my lord, it's a hard case in the sense that one post was there, that was filled up, but within 2 months, the post again fell vacant. When the lists, normal tenure of the select list is 1 year. And
Hard
that
case,
was
Mr.
there.
Mahanta. It is because if I go by equity, traveling beyond the law, might be a case of judicial impropriety.
No, I'm afraid that is not. This
Show
honorable,
me some,
my lord, that
show
is-
me some authority.
well, at least I can place one decision of this honorable court by Honorable Justice Amitabha Roy when his lordship was here in that capacity. Here, this is reported na? No, na? Unreported case. WPC কিমান বা এইটো ধৰিব লাগে 2008 কি নাম মমতা ভূঞা versus State Guwahati University. Here, I remember because this case came to my chamber and I realized that there is this tricky hardship is there. But nonetheless, then my junior, Mr. Chumwa, was there before the court on that day. Court ultimately considered and allowed the petition. Just I make it just read out last 2 paragraphs. This court, being a forum of equity, is persuaded to hold that the that
Present factual premises.
Ah.
demand
the present factual premises demand that the petitioner's plea ought to be treated with pragmatism and empathy. Empathy.
this petition is therefore allowed
This petition is therefore allowed. The respondent university will
for
permit the petitioner to take the paper which is still to clear in the final examination of the LLB. Here it was a case of LLB. The whole session was over. That period of 5 years or 6 years was granted to them. That was over. Then another term was given. That was over. No chance was left. The court said that this is some exception, some empathy is required. So on that count only, because this is a court of equity, I am solely invoking your lordship's jurisdiction in equity. Because rigor of law obviously will not stand before the equity if lordship finds that facts are such, case is such that he deserves relief. Kuntu?
It is made clear that this direction has been issued having regard to the extraordinary tax situation of the instant case and is not by
Yes.
any relaxation of the.
Yes,
Plus,
when I was on that side, I had also
must-
occasion for pressing this kind of case,
Yes.
at least on 3 occasions,
my lord,
and got the repetition allowed. So I am not
so my lord,
oblivious to it.
yes, my lord, I know lordship is experienced in the line.
Uh,
And that's why my prayer is that it
No,
may not.
show
form
me
precedent.
anything which is fitting in this kind of cases.
Well, I-
Because I think last week, another Honorable Justice Roy in the Honorable Supreme Court has passed exactly same kind of order.
Yes. Yes, against me. That will go against me.
Hmm.
That will go against me. But court there did not, because their whole fact situation was different. As I said, my lord, strictly applying the law, probably there is nothing. I cannot pray. But giving or going by the facts on the background of the facts here, fact that this is, well, what is that important fact or the relevant fact which your lordships may consider is that the person coming from OBC category of the society, he was selected, he is seeking absorption or appointment in a case belonging to the lowest rank of the service. This is grade 4, not the any higher group or higher cadre of the service. The lowest rank. And that will give him a sustenance. And particularly when, had there not been occasion of falling the post vacant again, probably I won't have the sons to urge even to that extent. Authorities say technical plea they have taken that since the post was filled up, notwithstanding the fact that the person has died subsequently within the limited period of 1 year, but legally constrained, the post stood filled up. So no further vacancy exists. Therefore, we could not consider. And technically, I don't dispute that. Technically, this is, they are in their position. But that technicality in certain situations should not be allowed to deny justice to some people, at least who deserves, who come from the lowest cadre of strata of our society. So I need your lordships, little sympathy, empathy, and to act within the principles of equity. What of you? There you go.
Yes.
Yes. Because my lord, law is always rigid, as your lordship says, my lord, this is too technical. At times, in certain facts, it may not fit in to do justice.
Yes, always law and justice.
Yes. Basic principle is to do justice.
Because upholding law, upholding justice, but if law and justice goes in different ways, then it is difficult. We are also bound by precedents.
True.
Otherwise, now Mr. Boisseau has in his counter affidavit
Yes.
cited an example.
Well, legally, they are in their place. But strict construing of the law, whether it would meet the ends of justice. Because after all,
Okay, we'll examine.
my lordship will appreciate the whole purpose is to do justice.
Yes.
Whether
we
person,
always,
yes,
but to our best of ability,
yes,
we try to see that justice is not, injustice is not done.
that is right.
Yes.
Here the ground is such, no injustice will be done to anybody. But some benefit will definitely come to a person who will be rather benefit. That's my submission, my lord. I leave it to your words.
Yes, Mr. Boisseau.
My lord, at page 19 of the read petition is the select list.
Yes, select list and waiting list.
My select list and waiting list.
Yes.
My lord, the candidature of Ranjit Thapa
Hmm.
at serial number 1. He was not suitable due to qualifications. Now, my lord, thereafter, the from the waiting list, Pradeep Bhagat was selected on 21/6/2023, man.
Yes.
Appointed, my lord, and on 23/6.
Who? Pradeep Bhagat.
Pradeep Bhagat. And on 23/6/23, 2023,
20?
23/6/2023,
Yes.
he joined my.
Okay.
And but this grateful employee, Pradeep Bhagat, expired on 15/11/2023.
Okay.
And although the office was informed on 16/11, but they could furnish the death certificate which was issued only on 17/5/2024.
Okay. Death certificate.
My lord.
Hmm.
And thereafter, the process has been initiated for fresh appointment. Here, my lord, the case is in a similar matter, my lord. The
Hmm.
law is already settled, my lord. Way back in 2002.
Hmm.
Here, my lord, the apex court held that panel ceased to exist with the appointment of the vacancy arising out of resignation of such appointee of vacancies arising subsequently. My lord, in that matter, one resigned, my lord, and the other person claimed, my lord. Then
Okay.
apex court held that. And this is the recent judgment of 2021 14 SSC. Similar, my lord, similar way,
2002, which paragraph?
my lord. Paragraph, my lord. Paragraph 4, my lord.
Paragraph 4.
Last fifth line, my lord.
Hmm. Okay. Yes. Anything?
And my lord, the recent judgment, your lordship mentioned.
I don't know. I have seen the headline.
My lord, this is Tej Prakash Pathak versus Rajasthan High Court, my lord, 2024 SCC online. Case
What does it say?
3184.
T.S. Prakash Pathak, you may remember that once the game is played,
My lord.
rule of the game is
Uh,
not to be changed.
not to be changed. And here, my lord, one thing
There was a reference in T.S. Prakash. That has been answered.
not directly related to this matter. But constitutional bench decided that the placement in the select list gives no indefeasible right to appointment.
Okay.
So when, my lord, there is a judgment holding the field by the apex court under Article 141, we have to honor it. my lord. No way out. Equitable relief cannot come in such circumstances where the law is settled for last 22 years. That's all. Okay.
Yes, Mr. Mohanty, anything?
The only thing I will just add, factual part, there is no dispute at all. I have already submitted. Well, the decision of the rendered in Sudesh Kumar Goel's case, where as my learned friend also pointed out, and Lordship, I indicated that Justice Roy and Justice Pankaj Mittal, they were the party here in this decision. He has placed it. These are my two. Imagine this decision. Here, Lordship will find 14 number of posts were there, 13 posts were filled up. This is for the Superior Judicial Service in the direct recruitment from the bar. The Superior Judicial Service in that cadre, the authority ultimately made a selection and appointed only 13 persons. One post was not filled up. Therefore, that who was already selected, he came before this court, that I should be appointed against that.
Okay.
Supreme Court ultimately said that, well, the discretion remains with the employer, whether they want to fill up that post or not. If they choose not to fill up that post, we cannot force them. They have filled up 13, they do not want to fill up another post, although the selection was made and
For 14
somewhat-
vacancies.
Yes. So, Supreme Court says we cannot direct, and more particularly on that facts, court said that this is in that cadre. Highly consider the highest judicial cadre of the district. Definitely court will not consider all these aspects. That is why I said, my lord, here the facts is totally different. Here it is the lowest rung in the service cadre, grade 4, and the person selected, Lordship has seen already, he belongs to OBC category, and my lord, somehow to earn his livelihood, he is trying hard. That's why before this honorable court, and there was no selection, nothing, no other person in the select list had it been the case otherwise.
He was competing for unreserved category post.
Unreserved category post here, category has not been shown, but he belongs to grade 4. He belongs to OBC. That is what my contention before this honorable court. Grade 4 peon. Therefore, well, these rigors, while acting under principle of equity, this court can always carve out certain space without even flouting the norms as laid down under 141, the Constitution. No, and Lordship is aware, such decisions are being passed, and I have placed one. There are also, in that case, Justice Sobita Roy, there is a line saying that the rigidity of law may be tempered with mercy in appropriate case. There is a line, my lord. I'm sorry that I couldn't. So in some cases, obviously, otherwise, my lord, 226 will have no bearing that way. It is always there, my lord. And therefore, equity was founded on this basis. The very foundation of equity is this, that when law fails to deliver justice, but hardship remains,
Hmm.
then equity must come in. This is the basic principle of law. Law and equity. With this submissions, my lord, I leave it to your watching. Deeply obliged.
Right, Mr. K.K. Mohanto, Learned Senior Counsel, assisted by MSN Begum, Learned Counsel for the petitioner. And Mr. Z. Bosho, Learned Standing Counsel, GHC for the respondent. Full stop. Okay, arguments are heard. Judgment is reserved. Because it is 4:30 already.
Already.
I could have dictated, but
I can.
Public.
Public.
Can it be taken up on 29th?
Mr. Somua, 29 is difficult.
Any other date, my lord, before your lordship goes off station?
Thereafter, I am going. Thereafter, I am going. So that is why I am not inclined to post the case on 29, because that is the last day before my going outstation.
If lordship, the matter is not too much, it will not.
No, I'll be in the division bench also, Mr. Somua. That is the difficulty. And they both have to go together. My esteemed senior brother is sitting in a division bench. That is why I am sitting in a division bench. Oh, sorry, single bench after the division bench. If that court does not fix any matter in single bench, I cannot.
Okay.
Have you understood?
Understood.
So it is very difficult.
It is
So
public
after some
opinion.
time,
Yes,
when maybe in the next year only.
maybe January. I talked to the court master.
তোমাৰ ফিক্স কৰি থোৱা আছে নে চিৰিজ এটা আফটাৰ ভেকেশ্যন কেতিয়া দিয়া আছে কেইটামান দিয়ে আছে Yes, how what is the issue?
Issue is a fixation of pay of the secretaries of this honorable registry. Fixation of pay, my lord, that
Who is appearing for the respondent? Mr. Nayak.
only which fitment table will be the appropriate one. That is the only thing to be
Okay.
decided.
মোটাতে ফিক্স কৰা আছে নেকি তো Mr. Chobo will do one thing. We don't know the roster. We can put it just for the purpose of fixing a date on 16 or 18 December. Then we'll fix a date.
Man.
That will do? Then we'll fix a hearing
Fine,
date
Lord.
as per the.
Or if we can, if lordship is pleases, my lord, we can, lordship can dispose it of that day itself also.
We'll
Because-
try.
yeah.
We'll try.
My lord.
But
Because it's not a.
before vacation, it is difficult.
My lord. So my lord is fixing it on,
18?
okay, my lord.
18? We'll fix a date for hearing. If in the first week of January it is possible or second week, we'll post it accordingly.
Well.
Because in the first week of January and second week of January, I have fixed some serious matters.
All right, Lord.
Uh,
As far as lordship convenience. my lord.
A. Somua for the petitioner, P. Nayak, Learned Standing Counsel,
Yes, Lord.
Finance.
Finance, and Mr. A. Borua, Learned Counsel, representing Mr. T.J. Mohanto, Learned Senior Standing Counsel, GHC, are present. List the case on 18.
18th of December.